So, Your Honor, we're here again moving for a judgment of acquittal on both counts. We understand that the standard for Your Honor's review is taking the evidence in the light most favorable to the state. Could a rational jury find that the state has proven all the elements beyond a reasonable doubt? And so I'm going to try to read my audience, that being you. You've already ruled, at least through the state's case, that there was enough evidence. And so what I'm going to do is readopt the arguments I make, but ask you to focus now just on the culpable negligence manslaughter charge, because that is the more serious charge. Of course, both of them are very serious. As the prosecutor alerted you, the guideline sentences for vessel homicide, 9 years in prison. The guidelines for culpable negligence, I think, is 11 years. So we're talking about two very serious charges. But in terms of the government or state's burden of proof, there is a higher mens rea element with regard to culpable negligence. And so even if the court is going to allow the recklessness charge to go to the jury, and I've argued to you why that shouldn't happen, because there is no evidence of a course of conduct by Mr. Pino to drive in a reckless manner. For the state to establish culpable negligence, there needs to be, apparently under McCreary, recklessness plus. Something beyond just being reckless. It has to be something even more serious. And to be clear, even if you were to grant the motion just as to the manslaughter charge, we would still be facing this recklessness charge. And I'm inviting the court to give greater consideration to that, if for no other reason that to try to get a jury to understand the difference between the two. I think you're going to find, if you haven't already gone through the nuances of the jury instructions, it is going to be a nearly impossible task to explain to the jury the difference between the two, because the language for culpable negligence incorporates the word reckless. And so it is particularly confusing. And so we're quite confident in our position that mere elision coupled with catastrophic injuries does not establish recklessness. The evidence presented through Mr. Albert, the lieutenant who served as the government's expert, I think the takeaway from his testimony, the government's theory when we brought him back, is that Mr. Pino simply did not see the marker, whether it was because the passengers were seated in the designated bow seats and raising their arms and distracting Mr. Pino, approaching a marker that is 5 feet lower to the water level than the other markers in the channel at a time, high tide, when that marker was at 6 feet above the water line, and the passenger seated on the bow would necessarily have obstructed the view of that marker. The combination of those things, under Mr. Albert's theory, would have required that Mr. Pino take some action to have the passengers clear the way for him to see, and that his failure to do that was the cause of the accident. That is the takeaway from Mr. Albert's testimony, all of which adds up to, at best for the state, ordinary negligence. Failure of Mr. Pino to create a proper ability to see this marker that's lower in the water at high tide. It does not evidence some course of recklessness, given that Mr. Pino had navigated that channel that day, both going up to Billy's Point and returning back. His operation of the vessel put no one in danger. He was able to navigate through that channel, coming back at the speeds that the state contends were, in their view, excessive, but apparently not so, because you've heard it already from other witnesses, including law enforcement officers, including David Rodriguez, who was traveling upwards of 55, if not 80 miles an hour in Biscayne Bay. And so it was ideal conditions to operate a vessel at the speed at which Mr. Pino was operating the vessel. So all that the state has as a theory is that Mr. Pino looking through a windshield with 7 girls sitting in a designated bow seating, some of whom were celebrating the birthday by waving their hands and singing, obstructed Mr. Pino's view. He did not see the marker as it approached in the last 9 seconds. There was plenty of time if he had seen the marker, according to Agent Albert or Lieutenant Albert, to avoid the marker. But of course, if he didn't see it, that explains why he hit it. And I say to the court, if you think that maybe there's recklessness there, we say not, based on all the cases we've cited, it certainly doesn't then elevate to culpable negligence. And so at a minimum, Judge, if for no other reason than to give the jury a simple question to answer, if they're going to have to decide this case because Your Honor is not prepared to grant a judgment of acquittal as to both charges, we submit that at a minimum, preserving our issues for appeal as to both counts, we suggest to you that the immediate option would be to grant a judgment of acquittal as to the manslaughter count. Thank you, Judge.
Thank you, sir. State.
One moment, please, Judge.
So start off with, if you can answer the
Yes.
issues of fact and dispute for the why the case, both counts should go to the jury at this point. And while my standard of reviewing the second motion for judgment is acquittal, and generally, by the way, we would have this argument post any rebuttal case by the state. So I'm going to take the arguments here and consider them renewed because I understand the state is going to call the rebuttal witness. Go ahead, State.
Your Honor, at this point, even with the defense having presented a case, this is not a scenario where a second judgment of acquittal should be granted. Number one, the claim that the defendant's view of the channel marker was obscured by girls standing and singing and dancing, I would point the court to the cross-examination of Miss Porter-Carrero, who testified that, yes, they were dancing and singing and all of that at some point on the boat, but I asked her very specifically, in the moments leading up to the crash, were people standing up and singing? And of course she said no, because it's illogical to believe that people are standing up and singing and dancing while a vessel is traveling just shy of 50 miles per hour through the water. Moreover, it is...
Well, there's a conflict in the testimony, right?
I would submit no.
Let me make it clear. No one has contended that anybody was standing. It was simply that they were raising their hands dancing
All right,
in their seats.
There's conflict because maybe one or two witnesses testified to something about moving their arms around, but in terms of how much of a view could or could not be obstructed, isn't there a question for the jury?
No, because the only witness who said anything about that was Ms. Porter-Carrero, and I asked her, was that going on in the moments before the crash happened, and she said no. So from the state's perspective, the defense established that at one point the girls were doing that, but not at the time in the moments leading up to the crash itself. So that's number one. Number two, there's no, even if hypothetically there were arms waving, the seats, they're meant to be seats. It defies logic to think that this vessel, which the court had the opportunity to see, the jurors had the opportunity to see, that young women seated on those seats, just the mere waving of their arms, none of them are like, mixed martial arts fighters or something. There's no way that their arms would have obscured the view of that channel marker. Beyond that, the defendant himself confirms that he saw the channel marker when he's at Elliott Key and talking with Lieutenant Thompson about how the crash happened. He talks about the fact that we were approaching the last channel marker. So clearly he knew it was there. Clearly his view was not obscured by these young women's arms. Now his view may have been obscured because I don't know, he closed his eyes for 9 seconds, he was looking at something else, he was looking down at a screen. I don't know what he was doing, but whatever it was he was doing, he did not see this for at least 9 seconds, which is a really long time when you're going that fast, or he did see it and just thought, I'm not going to do anything. Either way, when a hazard that you know exists is coming up rapidly to you and you have the ability to see it, if we just agreed in criminal courts that, well, as long as the person didn't see the hazard, then it's just negligence, that just does not make sense. And the law is supposed to make sense.
Well, so counsel raised the argument, well, even if there's evidence of recklessness, certainly there's not the greater amount of evidence to rise to culpable negligence. Can you answer that?
Well, I would submit to the court, as I did in our first JOA motion, had there not been all these additional people on the vessel, had there not been all the alcohol that we know was consumed by the defendant as well as the girls that were on the boat, if under that set of circumstances, and if he wasn't even traveling as fast as he was, if he, pursuant to the GPS data that we have, ran headlong into that channel marker when he had ample time to avoid it, I would agree this would just be vessel homicide. But this is reckless plus, because he did have 12 minors on the boat, many of whom had been consuming alcohol. He himself admits that he had been consuming alcohol. Now, he claims it was 2 beers. The jury gets to apply to his statements the same type of evaluation as they would to anybody else. Did that witness, or did his statements come from a person that might have, I don't know, a motive not to tell the truth? If this defendant was so brain damaged that he's making up, claims of other boats that now the defense says, yes, they weren't there, then maybe also he forgot how many beers he actually had. Or the converse could be true. He deliberately knew there was no other vessel, but he wanted to blame someone else for his actions. And he knew that he'd had more alcohol than 2 beers, but he wanted to undermine his liability, culpability, what have you. So this is not just recklessness. This is recklessness plus, because not only were there all those minors on the vessel, but even if hypothetically each of them only weighed 100 pounds, you're talking about an extra 1,000 pounds on the bow of that vessel, which, as the court has already heard, is going to make the vessel more difficult to navigate, especially given that boats are steered not from the front, but from behind. Obviously, boats don't have brakes, but we have so much more here than just a man who runs into a channel. We have a man with alcohol on board, with minors on board, with many minors on board, who also has a long-standing knowledge of that channel and where that channel marker is. So in terms of culpable negligence, I think we have absolutely established culpable negligence, because it is such an entire want of care as to almost be a deliberate disregard for the safety of those that were on his vessel.
How does the GPS at all play into this in terms of how the GPS was set or not set?
Set or not set?
In terms of the, assisting Mr. Pino, if at all, in the navigation. What was the only evidence is the GPS, right?
Right.
And there
Well,
was,
it's not the only evidence, but in terms of the track of the vessel prior to impact,
that's what I'm trying to-
absolutely.
okay. But there was a change in that.
The only change in the vessel's path right before impact was when he went further 5 degrees to port, which put him right on that path, which is why this is charged as manslaughter, not only on the culpable negligence theory, but also the state has pled that by intentional act he has committed manslaughter, because he may not have intended the death, which of course the jury instructions state, but he was the one deciding to go full throttle. He was the one deciding where to steer that ship. And he steered it, we know, 9 seconds prior to impact, right into the path where that was going to force him to hit the channel marker. I'm sorry?
The vessel had stayed on the original path without that change that was effectuated by the operator.
Yes.
Okay, then the marker would not have been hit.
I'm sorry, I didn't hear the first
marker
part.
would not have been hit.
No, I'm sorry, if the court could just back up. The premise,
The operator maneuvers the vessel seconds before.
9
seconds before.
9 seconds.
Prior to the maneuver, the vessel, if it had continued on the track without the interaction of the operator, would have not hit the marker.
Of course.
That's
Yes. It was his action that put him on that collision course, which I don't want to leave out the fact that, yes, for those 9 seconds, that channel marker was visible, but it was visible even prior to that.
okay. Let me ask this. You had pled in alternative theories under the manslaughter.
Yes.
So explain to me how, in terms of culpable negligence, how, if at all, or what the state would have to prove if you are proceeding under the alternate theory in culpable negligence.
Culpable negligence being the alternate or the intentional act?
There's two theories.
Right.
So if the state proceeds under the intentional act,
Yes.
there's the evidence of the claimed intentional act would be that change in direction.
Yes.
Okay. So culpable negligence would not be something that would need to be established by the state under the alternate theory as charged through the manslaughter.
Right. It's kind of like kidnapping. You can charge somebody with that they've moved someone with an intent to harm or terrorize them, or that they moved them with an intent to commit another felony. Either theory can work. Here, there are two theories for manslaughter. Manslaughter by intentional act, by the act of him simply choosing to go on a path that put him on a collision course, and or manslaughter by culpable negligence, because the way that he was operating that vessel was so grossly and flagrantly dangerous as to almost invite a proof that it was like almost a conscious disregard for the safety of others, quoting the
language. And that's based on more than speed alone?
Of course. There's never speed alone. And speed alone, although I know the defense likes to, chant that jingo, Luzardo in the 3rd DCA specifically said we reject the idea that speed alone is not enough. The 3rd DCA said speed alone is not enough until it is. But there's never only speed. There's speed plus the location, plus the weather conditions, plus, there are so many different variables.
Well, the nature of this channel.
The nature of the channel. It's a narrow channel.
Would you consider that in terms of the prior knowledge of Mr. Pino? Would you consider that something relevant, meaning the narrowing of the channel and understanding, how the channel moves?
Yes, because again, when we look at the way that part of Biscayne Bay, when it filters into where Card Sound is, there are only so many ways that vessels can traverse between those two bodies of water. And so by the defendant choosing to operate on the wrong side of the channel, maybe in and of itself doesn't create a danger, but if a person drives on the wrong side of the road, just because they see nobody's coming in the opposite path, well, the problem is with the nature of traffic, it's always moving. And we know that there were a lot of vessels around because within minutes after this crash, Good Samaritans are coming to the scene.
And so the totality of your position is that given the totality of the circumstances, the jury could find, a reasonable juror could find, a reasonable juror could find that the elements of the manslaughter, even under culpable negligence, are met. I don't want to put words in your mouth. I want to understand if that's the argument.
That is the argument, and I haven't had the benefit of sitting down and going through all the evidence like I will for the closing argument, but I think that all the highlights from the state's case in chief that the court, and I understand it's different standards, but all of that evidence that came in, none of it was undercut or undermined by the defense case in this matter.
Okay. Got it. Just one question from the defense, and then I'll be, I have for the defense. I'll allow you 2 minutes of rebuttal, but my question is, as the state charged the manslaughter under alternate theories, can you respond to the intentional act?
Of course.
Yes.
No one's claiming he intended to strike the marker. That's not the state's theory.
The intentional act of shifting the
Course, changing course.
Changing course.
Yeah. So the boat was on a path to clear channel marker 15.
Right.
Right? And so the GPS track shows the boat starts heading, changes heading, which the state says puts it on a collision course.
Okay.
So no one's denying that Mr. Pino was in control of the vessel. The state's theory is he's in control of the vessel, and the state's not contending that he was intending to, because the decedent had no evidence of blood alcohol. So there's no claim that the decedent was intoxicated.
Okay.
So that's a, that's a red herring. There were other girls on the boat who were intoxicated. No evidence that the decedent was.
Okay, well, I want you to come back to focus on, so under the alternate theory of manslaughter, intentional act,
Mm-hmm.
okay,
The intentional act would have to be he intended to hit the marker, which no one says he did.
okay.
He intended to operate the vessel. He voluntarily operated the vessel, but it was not his intent to hit the marker. The state's already told you repeatedly if that was his intent, he'd be charged with murder.
But what the state's position is, I think I understood, the intention to actually change course, even the slightest change of course, which then,
I think I understand your point. He changes course to the south. Had he continued changing further south, he would have avoided the marker.
okay,
Had he left the course as it was, he would have avoided the marker.
Okay.
So he's driving along, and the state's theory is the vessel in Mr. Pino's command starts heading further south, and the vessel is now on a collision course, according to the state.
okay,
But it wasn't Mr. Pino's intention to aim at the marker. There's no evidence that was his intention. So when we talk about an intentional act that's reckless, yes, I agree. If it was his intention to hit the marker, guilty. But that wasn't his intention. No one says it was. There's no evidence that was his intention. That's the point.
okay, I understand.
See if there's anything else I wanted to say. Oh, and then the state's reliance on Mr. Pino having consumed some alcohol throughout that day isn't sufficient under the Jackson case that we've cited, that has, when we submitted it to you in the form of the proposed jury instructions.
Right.
And so, since there's no evidence of impairment, no evidence of intoxication, what we're left with is nothing that could elevate this from, if you find reckless to be sufficient for a jury to consider, taking it to the next level of manslaughter and culpable negligence.
Consider the argument of counsel on the second motion for judgment of acquittal. As to count one, the court is going to maintain my position at this point that there is sufficient evidence to go to the jury on the manslaughter, and the motion is denied. As to the vessel homicide, there is sufficient evidence to go to the jury that the operation was vessel homicide operating in a reckless manner. So the motion is denied as a both counts. On the defense second motion for judgment of acquittal. And again, I'm going to consider this as the argument you would make and present post a rebuttal witness, okay? Because generally I'll take that after the rebuttal, but I didn't want to, timing-wise, keep the witness too long or keep the jury too long.
And may we inquire potential objection?
Absolutely. It's the state's intention to call Rudy Puig, the father of Kati Puig, not to get into anything other than Kati, prior to this crash, was healthy, was active, was an athlete, and that post-crash, she now is bound to a wheelchair and needs 24/7 medical care. And the reason why